1968 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်319 S.S.V RAMACHANDRAN APPELLANT vs K.P.A.N.S NARAYANAN CHETTIAR and 1 RESPONDENTS ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစော်မင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Civil First Appeal before ဦးကျော်ဆန်းဦး and ဦးစိန်သင်း Judges S.S.V RAMACHANDRAN APPELLANT vs K.P.A.N.S NARAYANAN CHETTIAR and 1 Respondents Code of Civil Procedure Section 47 Question relating to the satisfaction of the decree whether to be determined by the executing court held the question relating to the satisfaction of the decree as recorded in the execution case now under appeal is undoubtedly between the appellant as the decree holder through his agent, the respondent number 2 and the respondent number 1 as the judgment debtor. It shall therefore have to be determined by the executing court. Muhammad Qasim and others vs. Rukia Begum, ILR 41, all 443. C.H. Gash Raj Singh vs. C.H. Debbie Singh, AIR 1937, out 298, refer to Mr. G.N. Banerjee for the appellant, Wan Hope for the respondent number 1, Ujio San-U Judge. The point for determination in this appeal is whether Section 47 of the Code of Civil Procedure is a bar to the institution of the appellant suit being Civil Regular Suit number 1 of 1962 against the respondent in the District Court of Handawadi for a bare declaration that the compromise recorded in Civil Regular Suit number 14 of 1939 of that court being void, the compromise decree recorded therein is not binding on the appellant. Civil Regular Suit number 14 of 1939 was a suit on equitable mortgage against the respondent number 1. In the compromise decree recorded in that suit, this respondent consented inter alia to the preliminary decree for 21,409.2 rupee, 21,409 jet 13 pias, with interest at the agreed rate being passed against him. It is alleged by the appellant that as the decree remained uncertified and the mortgage properties had been nationalized by the government, the appellant through his agent, the respondent number 2, took out execution being Civil Execution number 3 of 1955 of the Court of the Additional District Judge of Handawadi, wherein the respondent number 2, acting in collusion with the respondent number 1, filed an application falsely and without authority that he had received jet 2,900 from the respondent number 1 in full and final settlement of the decree on behalf of his principal, the present appellant. In that execution case, a joint petition signed by the appellant agent, the present respondent number 2 and the respondent number 1 as the judgment debtor, as well as by Mr. R. Jaganathan, the advocate for the appellant decree holder was fine, stating that as the decree had been fully satisfied, the mortgage properties be released. It was submitted by Mr. Banerjee for the appellant that this joint petition to release the mortgage properties was made probably to enable the respondent number 1 to get compensation from the government for nationalizing the properties. The court accordingly entered full satisfaction and closed the case. There is no dispute that the respondent number 2 was the agent of the appellant decree holder. The appellant, on being aware of the alleged fraud and collusion, filed the suit mentioned above, being civil regular suit number 1 of 1962, but the court dismissed it, holding that Section 47 of the Code of Civil Procedure is a bar to the suit, referring to Mula Civil Procedure Code 11th edition. At page 118, under the caption Adjustment of Decree and relying upon Muhammad Qasim and others first, Rukia P.K.A.N. 1 and C.H. Gaj Raj Singh first, C.H. Debbie Singh 2. Hence this appeal. Section 47 of the Code of Civil Procedure say, all questions arising between the parties to the suit in which the decree is passed and relating to the execution, discharge or satisfaction of the decree shall be determined by the court executing the decree and not by a separate suit. The question relating to the satisfaction of the decree as recorded in the execution case in the instant case is undoubtedly between the appellant as the decree holder through his agent, the respondent number 2, and the respondent number 1 as the judgment debtor. It shall therefore have to be determined by the executing court. The suit instituted by the appellant was rightly held by the lower court to be not maintainable under Section 47 of the Code. In Muhammad Qasim and others first, Rukia P.K.A.N. Supra, the bench held as between the decree holder and the judgment debtor, the question of an alleged fraudulent adjustment of the decree must be gone into and decided by the executing court. Wallace J., a member of the bench, said in a separate judgment that he found himself unable to agree with the judge of the lower court when the latter said that, being an executing court, he could not in any case go behind the decree until the decree holder brought a suit to get it set aside. The learned judge further said that he was bound by law to disagree with the lower court, whatever his personal view might be. No doubt there are cases where in special circumstances it was recognized, in spite of Section 47, that the party had the right to bring a suit based on fraud in a matter which relates to execution, discharge or satisfaction of the decree, but there are clear authorities dating from olden days that the question now raised in the present appeal before us cannot be said to be otherwise than a question arising between the parties to the suit relating to discharge or satisfaction of the decree. Mr. Banerjee, for the appellant, submitted that the lower court should have at least treated the suit as a proceeding under Section 47 as provided in subsection 2 of the said section. It must be remembered that it is a matter left to the discretion of the court and when it was not invoked by the appellant himself, decree holder, it cannot be said that the court did not act judicially, even if the court exercised the discretion in favor of the appellant. It would still be subject to objection as to limitation of jurisdiction. No opportunity was ever given to the respondent number 1 as the judgment debtor to raise any such objection. It is now too late in the day to submit that the lower court should have exercised its discretion under subsection 2 of section 47 of the Code. In the result, the appeal fails and is dismissed with cause. Advocate fee 5 gold mohars.